much for that very warm welcome. It's a very great pleasure to be back in Lincoln. As Duncan says, I was here last year when the university very kindly awarded me an honorary degree, which is a great privilege, particularly as you don't have to do any work for it. But I'm now back to perhaps sing for my supper, as I didn't do on that occasion. And the title that you've asked me to talk about is Wiping Out the Rights We Wrote, the UK withdrawing from the ECHR, the European Convention on Human Rights, and you'll see just on the edge of the screen it ends with a question mark. And that question mark is absolutely essential. Now, if this was an academic lecture, or if I was delivering a court judgment, I would expect you to wait until the very end of what I was going to say before I reached my conclusion. But you have to understand I'm a journalist, and journalists try to put the most important bit in the opening paragraph, what we call the intro. So here it is. Here is my conclusion. The United Kingdom is not going to withdraw from the European Convention on Human Rights, at least not yet. Now, I hope you won't think I've brought you here under false pretenses. You will wait and hear the rest of the lecture. If there are any journalists here and they wish to rush next door to the Lincolnshire Echo, feel free to leave now, or even start tweeting. You could possibly say, legal commentator claims Tory human rights reforms on hold. That's what I'm going to say, because this is a lecture about the Conservatives and their policy. You won't be surprised to know that I don't think the Labour Party or the Liberal Democrats are planning to pull out of the Human Rights Convention. Neither do the Scottish Nationalists nor the Greens. I don't know about UKIP, but I don't suppose they are actually going to form the next government or even hold the balance of power, but you never know. But this is really about the Conservatives and their policy. Now, I want to take you back 5 years to the manifesto that the Conservatives brought out just before the last election. That said, we will replace the Human Rights Act with a UK Bill of Rights. Now, what is a UK Bill of Rights? I wasn't sure then, and I'm still not quite sure now. But we didn't really find out because, of course, the Conservatives found themselves in coalition with their political opponents. And the way that you resolve a problem when you're in coalition with somebody, or indeed you can't resolve a problem otherwise, of course, to set up an inquiry and to tell it to go away and think about it for 2 years. So the government set up what was called a Commission on a Bill of Rights. And this was set up in March 2011 with 4 Conservatives and 4 members appointed by Nick Clegg. They sat for 2 years, and needless to say, they didn't agree at all. Helena Kennedy was, in fact, a member of it. Now, the Commission reported at the end of 2012, but by then, Chris Grayling had replaced Ken Clarke as Secretary of State for Justice and Lord Chancellor. And he'd already written off this commission. This is what he said in a newspaper article that he wrote. We have to accept that there are limitations to what we can do as part of a coalition. Whether we like it or not, both Labour and the Liberal Democrats disagree with us about the scale of change that's needed. The Minister promised rather magnanimously that he would actually read and digest the report of this Commission on a Bill of Rights, but he said, we will also be looking clearly towards the next election and starting work on ensuring that we have a real plan for change then as well. And then the killer sentence, I believe that it is time to examine how to curtail the involvement of the European Court of Human Rights in UK domestic matters. So here we are, we're at the end of 2012, and Chris Grayling is starting work on a real plan for change that will be ready for the election that is then 2.5 years off. Well, work starts, it all goes a bit quiet, and the next thing we come to is 9 months later when Chris Grayling speaks to the Conservative Party conference. Is the plan ready? No, not quite. He says, in the new year, the Conservatives will publish a document setting out what we will do. And then later in the year, we will publish a draft bill which will set out in legal detail exactly how our changes will take effect. So that's 2 documents in the new year, a policy paper and a draft bill later in 2014. Now, New Year is one of those wonderful phrases in the English language, one of those elastic phrases. It means any particular time that you choose within, what should we say, a month, 2 months, 3 months. Well, I'll tell you when this policy paper came out, and you can tell me whether it counts as the New Year. It came out on the 3rd of October 2014, which was a little bit late into the new year, but nevertheless it was 2014, was the year, and it was timed carefully to be just a day or two after the Conservative Party conference. But it confirmed that a bill was imminent and that it would be at the heart of the party's plans. Let me read you from this policy paper last October. We will shortly be publishing a draft of this bill to begin a process of engagement and consultation on the best way to achieve our aims. This will ensure that we deliver our reforms in a comprehensive and credible way. Now, shortly, that was the key word in the sentence I just read you. Shortly is quite an elastic word, a bit like New Year. And the paper used it twice. It said, we will shortly publish a draft Bill of Rights and Responsibilities for consultation. Now, we hacks, I'm afraid, we tend to be rather cynical. It goes with the territory. But it was absolutely all right because there was a definition of shortly in a press release which the Conservative Party sent out last October. It said, at the heart of the reform will be a new British Bill of Rights and Responsibilities that will restore common sense to the application of human rights in the UK. A draft of the bill will be published for consultation before Christmas. Now that is absolutely specific, before last Christmas. So in early December, I spoke to Duncan French and we agreed on the subject of this lecture, and I thought, that's fine, bill out before Christmas, 3 months to read it and analyse it and prepare for this lecture. You won't be surprised to know that Christmas came and went and there was no draft bill. In January, the Times had a story about what might be in this bill. It was a draft of a draft, if you like. And apparently it quoted the Human Rights Convention. It said there were going to be a number of exceptions in it, such as the right to vote doesn't apply to prisoners, and the right not to suffer inhuman and degrading punishment doesn't prevent courts ordering whole life tariffs. It had been initialed with the initials MH, which was a clue to one of its authors, or possibly both of its authors, because curiously they both had the initials MH. One of them was Lord Howard of Lympney, the former Home Secretary Michael Howard, and the other was a QC called Martin Howe. So one of them, or both of them, seemed to be working on this particular draft paper. Well, by January, I had decided that the government wasn't going to publish this draft bill before a thing called the Global Law Summit, which was a couple of weeks ago at the end of February, because it wouldn't look terribly good for the government, or at least the Conservatives, I shouldn't say the government because it's not the coalition, the Conservatives to be publishing this draft bill diminishing human rights when they were running a big conference on the back of Magna Carta to actually laud human rights. It wouldn't look terribly good. Well, at the pre-summit reception a couple of weeks ago, I started asking around as to when this particular draft bill was coming out. The date for this lecture was approaching rapidly, and I was anxious to see it and read it in order to tell you what was in it and give you the analysis that I have promised. Well, nobody seemed to know, and then the message just began to change slightly. It wasn't that people didn't know when it was going to be published. What it was, the message I was getting, was they thought it wasn't going to be published at all. And I was rather mystified. So the following morning, I collared Chris Grayling as he was receiving various diplomats arriving at the conference centre in Westminster, where this Global Law Summit was taking place. He and I have to say, don't talk very much. He's never given me an interview, and I don't think he ever will. But I went straight to the point, and I said, you know, when's your draft bill going to be published? And this is what he said. It's a decision for the Prime Minister as to whether he wants to do it. And that was all. As to whether he wants to do it. As I was digesting this, I wrote it all down as to whether he wants to do it. Grayling said, oh, sorry, I've got to talk to lots of diplomats to finish talking to, and that was it. But as to whether he wants to do it, Prime Minister, this is the bill announced in 2012, confirmed in 2013, scheduled for publication in 2014, and it might not be published before the election in 2015 after all. Well, if it was a matter for the Prime Minister, I need to know what was going on, so I rang Downing Street. Could they tell me when the bill was going to appear? They went away and thought about it, and the answer was unfortunately not. They said, we've set out our strategy in detail, and work is ongoing on the proposed legislation. That was a formal, on-the-record quote from a number 10 spokesman. And what does that mean? Well, we've set out our strategy in detail, presumably means we've told you quite enough for now, so stop asking us any more difficult questions. And work is ongoing means we're nowhere near ready. And there wasn't even a promise to publish this draft bill even shortly, to any specific timetable that you might have, even an elastic one like shortly. Well, I wrote all this up in a trade paper called the Law Society Gazette at the beginning of last week, just to see what the reaction might be. It's what we journalists call flying a kite. You sort of put the kite up and see where it flies to. And the response was instructive, because in fact there was no response at all. There was quite a bit of interest on Twitter, but there was absolutely nothing from the Conservative Party. Nobody contradicted me, nobody said I'd got it wrong, no complaints, no corrections, nothing. So I think my conclusions must be true. There is a widespread view among senior Conservatives that we are not going to see this much heralded draft bill before the general election. So what's gone wrong? Well, people talk about drafting difficulties. Now, I'll come on to what the bill may say in just a moment, but I can see why there might be drafting difficulties. One of the proposals in the Conservatives' policy paper that came out last October was that human rights law would apply only to the most serious cases. It said there'll be a threshold below which the Convention rights won't be engaged, ensuring that the UK courts strike out trivial cases. Now, where is that threshold going to be set? How do you define what trivial cases are? And who defines it? Is it the courts? Is it the government? Is it Chris Grayling? These are quite difficult questions. All you can do if you're drafting a bill is put something in very general terms and leave it up to the courts, which presumably are quite capable of deciding for themselves what's trivial and what's not. The reality is that when people tell you there are drafting difficulties, it means there are policy difficulties. And people said to me in the Conservative leadership, oh, you know, there's no particular hurry. Why are you going on about our draft bill? All right, we promised it, but, you know, we've got the policy, and when we win the next election, say the Conservatives, then you'll get this draft bill, and there'll be plenty of time. We're not going to rush into this just in the way that Labour rushed into their Human Rights Act 1998, a year after they won the election in 1997. We want to consult, we want to talk to people, and so on. Well, that's perfectly fair and quite reasonable, but it's not what the Conservatives promised. They said we would have a draft bill in good time for the election so we could see exactly what we were voting for. And of course, Conservatives say, but look, you've got this policy paper, you know, the one that I'm about to talk about. Why do you need to see the bill? Well, the answer is, I want something that stands up to proper, rigorous legal analysis. That is the purpose of a draft bill. The aim is to see whether the Conservatives can set out their proposals in language that will stand up in court so that we can analyse them, see exactly what they are, strip it out of the rhetoric, and use words that will actually mean something and will change the law. That is what a draft bill should do. It's not what a policy paper does. Now, why is it so important, though, to see the draft bill, to see what they're actually proposing? Now, this is where I have to step back a bit and tell you a little bit of law. Some of you are law students, some of you are familiar with this, some of you are not law students, some of you may be new to this. So those who are familiar with this should bear with me, and if you're not, you may find this useful if you ever find yourself writing a policy paper for the Conservatives. Let's start with a little bit of history. Let me take you back to the aftermath of the Second World War. 10 Western European countries, former allies, created a body dedicated to human rights. It was called the Council of Europe, and it was created in London by the Treaty of London, signed in 1949. Now that is long before the common market, as we used to call it, long before the European Union. The Council of Europe now has 47 member states right across Europe, and it's entirely separate from the European Union, which has 28 members. So it's important to understand you've got two separate pan-European bodies with separate names, and separate roles. They overlap because every country in the EU is a member of the Council of Europe, but obviously not every country in the Council of Europe is a member of the EU. They have very similar sounding locations and bodies and functions, but our job is to try and keep them separate. Well, the first task for the Council of Europe members was to draft an international agreement that would allow individuals to bring human rights claims against states and would bring those claims to an international court. That was the first thing that the Council of Europe wanted to do. In the aftermath of the Second World War, it was important that no government could claim state immunity for their actions. No government could say, well, we're the government, we can do what we like, we run the country, we can lock people up without a trial, we can kill people, we can shoot them, we can do whatever we like, because we're the government and somebody working for the government can do what we like either. That was the fundamental premise of the Human Rights Convention, this international agreement, and to be fair to Chris Grayling, he entirely supports that. The Human Rights Convention was drafted in around 1950, 1951. It's been amended a few times by amendments which are called protocols, funny name, but nevertheless it has some pretty basic protections, pretty basic rights. It protects the right to life, although if you think back to the 1950s it used to allow the death penalty, it doesn't anymore. It still allows the police to shoot rioters where absolutely necessary, but that's not encouraged. It prohibits torture and inhuman or degrading treatment or punishment. It protects liberty, it protects the right to a free trial. It protects private and family life. It protected privacy, in fact, long before we developed a privacy law here in England and Wales. Although privacy must be balanced against another right that it protects, which is freedom of expression. And most of the convention has balancing rights. You balance one thing against another. Each right is internally balanced. These are not absolute rights, and that's pretty fundamental. Now, the reason why the lecture is called Wiping Out the Rights We Wrote is that the man who drafted the agreement, this convention, was a chap called Sir Oscar Dowson, a former legal advisor to the Home Office, and a prominent part in the negotiations was played by Sir David Maxwell Fyfe, who later became Home Secretary, and Lord Chancellor, Viscount Kilmuir he became. And of course, the British were very key to these negotiations, that's why that is why the convention very much reflects English common law and why it's written in very beautiful, very simple, very plain and very clear English. But even then, as now, the United Kingdom was pretty hostile to the idea of individuals taking the British government to an international court which could make binding rulings. So the original idealised agreement was watered down a bit, and the right of individuals to take claims to this European court was made optional. And it was on that basis the United Kingdom first ratified the Human Rights Convention. It was, in fact, the first country to ratify the convention in 1951, and it came into force in 1953. This convention, this international agreement, established a court in the French city of Strasbourg. And Strasbourg, of course, if you know your geography, is on the border with Germany. It's in France at the moment, but at various times in the past 200 or 300 years, it switched between France and Germany, and it's very much a symbol of reconciliation between France and Germany. The very name Strasbourg sounds German. Many of the place names around Strasbourg sound German. The wine looks German. I mean, it's a very interesting Franco-German city where they still have a Franco-German dialect, and when I used to go there was even a newspaper published in this dialect. In Strasbourg there was also, as well as a court, there was what was called a Commission on Human Rights, Human Rights Commission, which filtered applications to the court. Now that was abolished in 1998, and I think most people saw the need to replace this part-time court and part-time commission with a full-time human rights court, but nobody told the architect who was in the process of designing the new court building. This was Sir Richard Rogers, now Lord Rogers of Riverside. He was designing this building, which was completed in 1994. And if you ever see pictures of it, what you see is two huge circular buildings, one slightly bigger than the other, with a sort of tail behind each of them. trailing behind with offices. The two big circular buildings are the courtrooms, and the trail of offices are separate because in those days there was, as I say, there was a Commission on Human Rights which had the smaller courtroom and the court itself which had the larger courtroom, and they were meant to be separate. And this was expressed in the architecture. Unfortunately, within a few years of the building being opened, the Commission was abolished. There's no need for the Commission courtroom. There's very little need for the court's courtroom because it really only sits about once a month. It does most of its decisions behind closed doors. It has very few oral hearings. Well, let's go back to the history. Labour came to power in 1964, and Harold Wilson's government announced that the UK would accept the right of individual petition from January 1966. Nobody quite understood at that time what that meant. That meant that individuals could take the British government to the European Court of Human Rights. Nobody quite understood it because at that point the court had only heard two cases. It wasn't until a decade later, 1975, the court first made a ruling against the United Kingdom. That was a case called Golden about prisoners' correspondence. And it wasn't until 1979 that the court actually disagreed with the decision of the House of Lords, the Law Lords, which was then the United Kingdom's highest court. That was the Sunday Times thalidomide case about free speech. Well, there were about 50 or so defeats for the British government over the next 20 years or so, as one or two lawyers, in particular Lord Leicester, Anthony Leicester QC, learnt what the court could do and how to use it. But the crucial thing was, in those days, you had to go to Strasbourg to bring your case. Obviously, you could send your application off by post, but Strasbourg, the European Court of Human Rights, was the only court where you could enforce this Human Rights Convention, these rights like the right to life and so on. You couldn't bring a claim here in the United Kingdom. Well, that was fine, but from the 1970s on, there was pressure for what is called incorporation of the convention, bringing the Human Rights Convention into our own domestic law, the law of the United Kingdom. What does that mean? Well, let me give you an example. As recently as 20 years ago, members of the armed forces knew that they would be sacked if they were known to be gay. The policy was brutally simple: if you're out, you're out. Now, this was what the Ministry of Defence said in guidelines issued in December 1994. It was only just over 20 years ago. Homosexuality, whether male or female, is considered incompatible with service in the armed forces. This is not only because of the close physical conditions in which personnel often have to live and work, but also because homosexual behaviour can cause offence, polarised relationships, induce ill discipline, and, as a consequence, damage morale and unit effectiveness. If individuals admit to being homosexual while serving, and their commanding officer judges that this admission is well-founded, they will be required to leave the services. So that was the policy 20 years ago. A number of troops, for various reasons, were sacked for being gay. Either somebody told on them, they came out, or whatever it was. And these were, private soldiers, NCOs, officers, all exemplary service personnel, and they lost their jobs. And they complained that they had suffered a breach of their human rights. And they went to the courts here, and Lord Bingham, the then Lord Chief Justice, said in 1995 there was nothing he could do about it. They would have to take their case to the Human Rights Court. They did, and in 1999 they won. And the government immediately withdrew this guidance, allowing gay troops. I think the government was rather relieved that it was forced into doing this by the Strasbourg court. It meant that they could tell the generals who they suspected were against all of this, well, nothing we can do about it. But in fact, everybody was perfectly happy, and the armed forces are now very proud of their devotion to equality and respect for diversity and so on as everybody else. So that was an example of a remedy that you couldn't get here in this country, but you had to go to Strasbourg to get. And then in the following year, 2000, that was when the Human Rights Act came into force. And the thinking behind that was simple enough. If these claimants, the gay troops, could have enforced their human rights here in the United Kingdom, there wouldn't have been any need for them to have taken their case to Strasbourg. And that would make things much quicker, much easier, much simpler for claimants. They were going to win in Strasbourg. Why not allow our courts to apply the Human Rights Convention and to say that it was a breach of their rights to be sacked just because of their sexual orientation? It would be cheaper, it would be easier, and it would avoid embarrassing defeats for the British government in the Human Rights Court. So the aim was to bring rights home. The idea was to give judges in the UK the same powers as the Strasbourg judges had, and the idea behind that was that they would reach the same sort of decisions as would be reached at the European Court. But there was another important objective behind the Human Rights Act 1998, which came into force in 2000, and that was to preserve parliamentary sovereignty. It was absolutely essential that MPs should have the last word, and courts couldn't overrule clear laws passed by Parliament. So the Human Rights Act is really a rather subtle piece of legislation. It's quite a balanced and difficult piece of legislation to cope with, because it incorporates the Human Rights Convention into our laws in a number of very subtle ways. Let me tell you about one or two of them. Section 3 of the Act says, so far as it's possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. Now, that's quite tricky, so let me give you another example of how that works. So far as it's possible to do so, primary and subordinate legislation must be given effect in a way that's compatible with Convention rights. This is a case about a basement flat in a rather nice area of London near the old Brompton Road. The tenant was a man called Hugh Walwyn James, and he died in 2001. He'd lived there for nearly 20 years, and he was what was called a protected tenant under the Rent Act. That meant that his spouse, if he had one, could stay in this rather desirable flat after his death. I say his spouse, they didn't actually have to be married, because the law said, the Act said, that a person who was living with the original tenant as his wife or husband was treated as the spouse of the original tenant. I don't know if you can guess where this one is going. There was somebody living with the tenant, but he was a man. He was called Juan Godin Mendoza. He couldn't have married Mr. Walwyn James in those days. He couldn't even have registered a civil partnership. That didn't come into effect until 2005. But he said he had been living with Mr. Walwyn James in a monogamous relationship in the same way as a spouse. So the question was, could he inherit the tenancy? Now, the Human Rights Convention certainly doesn't guarantee you a right to a home. It doesn't give you a right to a tenancy. But what it does say that if the state is going to give you these rights, then it can't discriminate against you on the grounds of your sex. So Mr. Godin Mendoza would certainly have won his claim in Strasbourg just like the gay troops. Now, he could have taken his case to the Human Rights Court, but you have to start in the domestic courts. You have to start here. And the question was, could the UK courts save him the train fare to Strasbourg? Could the law lords use this provision I've told you about? Could they read down the convention using the jargon? Could they read down the Rent Act to make it compliant with the Human Rights Convention? In other words, was it possible for primary legislation to be given effect in a way that was compatible with convention rights? Yes, it was, and Mr. Godin Mendoza won his case in 2004. There was no need to go to the Human Rights Court, and that was Section 3 of the Human Rights Act. You also need to know about Section 6, which says it's unlawful for a public authority to act in a way that's incompatible with convention rights unless there's legislation in the way and it can't get around it. And public authorities include courts, so there you are, public bodies can't act incompatibly with convention rights. And the last bit of law I want to tell you about is Section 2, and that says a court determining a question which has arisen in connection with convention rights must take into account any judgment of the European Court of Human Rights. Now, I could deliver you a whole lecture on what taking into account means. I'm not going to do that tonight, you'll be relieved to know. 10 years ago, the law lords thought it was right to mirror what was being said in Strasbourg. After that, they were more willing to have a constructive dialogue with the Strasbourg court. But take into account does not mean the courts here are bound to follow Strasbourg rulings. On the other hand, they can't ignore Strasbourg rulings completely, because if they did, if the law varied so much between this country and Strasbourg, there wouldn't be any point in the Human Rights Court, because you'd still have to go to Strasbourg to enforce your human rights. So there we are. I've told you what's in the Human Rights Convention, the right to life, property, privacy, and so on. And those rights are set out in the Human Rights Act. And I've also told you how the Act works. Legislation must be interpreted compatibly with the Convention where possible. Public bodies must act compatibly with the Convention, and courts must take into account decisions by the Human Rights Court, what's referred to as Strasbourg jurisprudence. But what I want you to understand very clearly is the difference between the Human Rights Act, which is an act of the British Parliament, and the Human Rights Convention, which is this international agreement drawn up in the 1950s, signed by 47 countries. That Human Rights Convention can be amended. I told you there were these amendments called protocols. There have been 16 of them. But those amendments can be done, as you might expect, only if all the people who've signed up to it, all the states have signed up to it, agree. So only if 47 member states, as it is at the moment, agree, can the convention be amended. The convention is binding on the United Kingdom as a matter of international law. We can pull out of it if we wish to, but we can't change it by ourselves. The only way of changing the Human Rights Convention is if everybody who signed up to it writes a new protocol, changes it, or whatever. And of course, the Human Rights Act is an act of Parliament. It's a statute. It's created by the UK Parliament. It can be amended by any other, by a future statute, future act of Parliament, like any other statute. And it can be amended by any government that can command a majority in Parliament. So that's enough history, and what I want to come on to now is current affairs. Let's go back to this policy paper I told you about at the beginning. I've told you that it was issued last October, but I haven't told you very much about it. I haven't told you what it was designed to achieve. First, it says, our reforms will mean that the European Court of Human Rights is no longer binding over the UK Supreme Court. The bill promised in the policy paper, this draft Bill of Rights and Responsibilities, will end the ability of the European Court of Human Rights to force the UK to change the law. Well, it sounds all right to begin with, but just hang on a moment. There's nothing in the Human Rights Act that says that the European Court of Human Rights can bind the UK Supreme Court. There's nothing in the Human Rights Act that allows the European Court of Human Rights to force the UK to change the law. All that the Act says is that our courts must take into account decisions of the Strasbourg Court. So what are the Conservatives going on about? Well, they're not talking about the Human Rights Act at all. They've mixed the Human Rights Act up with the Human Rights Convention. Article 46 of the Convention, and here is the Convention in this handy pocket-sized guide. Article 46 of the Convention says that the countries that have signed it undertake to abide by the final judgment of the court in any case to which they're parties. So that's what the Conservatives want to get out of. They want to get out of this obligation to abide by the final judgment of the court in any case they lose. They want the Strasbourg Court to become an advisory body only. But as far as English law is concerned, it is an advisory body already. All the Supreme Court has to do is to take account of its decisions. Now, you could put that into a new Bill of Rights, you could make domestic law clearer if you wanted to, but it wouldn't make any difference. Because whatever you put in domestic law, the United Kingdom still has its obligation under international law under Article 46 of the Human Rights Convention to abide by adverse rulings. And you can't change that by passing legislation. An Act of Parliament can't override an international treaty. How are the Conservatives going to get round that one then? And that was why we wanted to see the bill, and we're still waiting. Now, of course, governments can amend treaty obligations if they get the support of the other parties. And that's where the Conservatives have got really confused. In their document, they say, during the passage of the draft Bill of Rights and Responsibilities, they say, they will engage with the Council of Europe and seek recognition that their approach is a legitimate way of applying the Convention. But their approach is to breach the terms of the treaty. Now, the Council of Europe, this international body with 47 members, it administers the treaty, but it can't let the United Kingdom off its international obligations. Only the other member states can do that. Now, will they? Well, I should think some of them would be very happy to do that, but only if the same applies to them. You know, countries like Russia, Turkey, Ukraine, they'd be very happy for the Human Rights Court not to be binding, to be an advisory body only. But you can be absolutely sure that if they're going to allow the UK to treat the decision of the court as advisory, and the UK has a very good record, with only one exception of abiding by the Human Rights Court, then these other countries in Eastern Europe will want it to be advisory. And you can be absolutely sure that the more mature democracies of Europe are not going to let the newer democracies of Europe, as they're referred to, get away with that. So, well, then what happens? Well, the Conservatives say, in the event that we're unable to reach agreement, the UK would be left with no alternative but to withdraw from the ECHR. Well, at least that's honest. At least that is telling it like it is. What the Conservatives are saying in their policy paper is, if these countries don't change the rules of their club, then we won't play anymore. It's not as simple as that. Under the Convention, we have to give 6 months' notice. We would still be bound by rulings up to the date we leave. Perhaps we wouldn't care. It's a bit like a tenant doing a midnight flit and not bothering to pay the last month's rent, but in any event, we would be out. And we would be out not just of the Human Rights Convention, but we would be kicked out of the Council of Europe, which is the body that administers the Human Rights Convention. The Council of Europe is a pretty boring place, but it does a lot of very good work, far beyond the area of human rights, gets very little reported, it's very bureaucratic, it spends a lot of money, but it does do good work, it's worthwhile, we pay towards it, we would be out. Maybe we wouldn't care very much about that, we would save a certain amount of money. But what would the consequence be of leaving the Council of Europe? Well, no country can ever join the European Union without first joining the Council of Europe. Countries like Albania, which want to join the EU, have to start in the Council of Europe, they have to learn how to be democratic, they have to learn about human rights, and once they actually have respectable respect for the law and respect for the structures, they can join the EU. So, if we were to leave the Council of Europe, would we be thrown out of the EU? I don't think so. Nobody knows. I don't think so, because I don't think the EU would want that. But, it may well not be worth trying to find out. And if we stay in the EU, then we're bound by another thing, which I haven't got time to tell you very much about, which is the EU's own Charter of Fundamental Rights, which is actually even more effective than the Human Rights Convention, because to the extent that it covers matters of European law, it's directly binding on our own courts. Well, what I've tried to do tonight, ladies and gentlemen, is to persuade you that the Conservatives' policy is legally incoherent. In summary, what they want to do is to use an Act of Parliament to amend an international treaty, and you just can't do that. So, is that why this draft Bill of Rights and Responsibilities has been blocked by David Cameron? Well, it would be nice to think that he's noticed that this policy that he himself has supported at his party conference is legally incoherent. I rather doubt it. I think the real reason is political, and I can speculate on that. I mean, what are the political advantages of leaving the ECHR? What are the political advantages of this policy? Well, there's a rich seam of anti-Europeanism to be tapped here. Ignore the fact that the ECHR has nothing to do with the EU. Ignore the fact that the EU's own court in Luxembourg is very sniffy about a proposal which was that the EU itself would sign up to the Human Rights Convention. Ignore the fact that the Council of Europe was created in London and the convention was drafted by UK lawyers and it was in line with common law. As far as the Conservatives are concerned, they think there are votes to be gained by saying that UK judges should decide the law in the UK. Well, that was the thinking behind this policy over the past couple of years, but it works only if the Human Rights Court is constantly finding against the British government. And for a while, that argument seemed to have some legs. Chris Grayling, Justice Secretary, was very exercised nearly 2 years ago when he discovered that the European Court had decided by a bare majority of 9 votes to 8 that UK laws banning political advertising on television or radio do not breach the human rights of a charity campaigning for animal welfare. In other words, this was a campaign by animal defenders. They wanted to advertise on television. They were not allowed to because we don't allow political advertising on television. They said it was a breach of their human rights, and they very nearly won. There was only 1 vote in it, and they lost. Sir Nicholas Bratzer, a British judge who was president of the court, was required to hear the case, but even though he was president, he wasn't allowed to preside. I've not spoken to Bratzer about this, but he was certainly one of the 9 who voted in favour of the British government's position. And if he had decided the case against the UK, then all things being equal, the government would have lost. I'm pretty sure he will have persuaded a lot of people, a lot of the other, at least 1 or 2 of the other judges, to vote in favour of him. If the government had lost, it would have been a disaster. The reason for that is that we would have then had paid political advertising on commercial television rather than the party election and party political broadcast we have at the moment. The parties would have had to raise a lot of money from rather dubious ways, and the whole system would have been out of kilter. But rather than thanking Bratzer, the British judge, for saving the British government from something which I fully accept would have been undesirable, Grayling chose to complain about what might have been and how near we were to disaster. Then there was the case of Abu Qatada, the radical cleric. We wanted to deport him to stand trial in Jordan. The European Court decided there was a risk he might be tried on evidence obtained through torture, but in fact all that was necessary was for the Home Secretary to obtain assurances he wouldn't be tried on tainted evidence. She did so. He left the UK. He was found not guilty because there wasn't any evidence that wasn't tainted, and that was the end of Abu Qatada. And then there were a couple of recent cases referred to by the Conservatives. One was about murderers given what are called whole life tariffs. In other words, they were told they would never be released. In 2013, the European Court decided that was inhuman punishment because there wasn't any possibility that they'd be let out. And the Court of Appeal rather cunningly threw a lifeline to the government last year. They found a way of saying that there was still a possibility of an eventual release on compassionate grounds, and that was enough to comply with the convention. The government put that to the court. The court said if it's good enough for the Court of Appeal, it's good enough for us. And the Strasbourg court said there was no breach of the convention. It was very good for the British government, but didn't really help Chris Grayling and his arguments. The most high-profile case, of course, that you must be thinking about is the one about prisoners' votes. And the concern by the Conservatives, as expressed in their policy paper, is that the court has developed what it calls, or what the policy paper refers to as mission creep. They say that the issue of the franchise was deliberately left out of the original convention. Well, it was, but it's added in one of the protocols. And they complain that the Strasbourg court regards the convention as a living instrument. It develops a convention. Well, you know, that's what courts do. Not all courts, not all judges. You go to the United States Supreme Court and you see Justice Scalia, who has a more originalist approach. He asks himself what reasonable people living at the time the US Constitution was drafted would have thought it meant. But most judges, I think, tend to take the view that you have to look at the world in which you live at the moment and you have to develop it. You just can't be quite sure how far to go. The prisoners' votes case, it was actually nearly 10 years ago that the Grand Chamber, which is a sort of appeal chamber of the Human Rights Court, decided that the blanket ban on prisoners voting breached the Human Rights Convention. That was in a case called Hurst. Hurst wasn't an axe murderer, he was an axe manslaughterer, but murderer sounds better. But he was actually convicted of manslaughter of his landlady by hitting her with an axe. Not a terribly nice man, but nevertheless very important in this. And as you know, both Labour and the Conservatives have done everything they could to avoid implementing the decision of the Human Rights Court, which is that the blanket ban on prisoners voting is unlawful over the past 10 years. But they don't have to do very much. You could just give the vote to a very small number of prisoners serving very short sentences, and that would be enough to comply, I think, with the court, but that's not what people are prepared to do. The decision on how far you need to go is not a matter for the court normally, it's a matter for what's called the Committee of Ministers. These are delegates of the various countries, diplomats, who meet in Strasbourg, and they have recognised the reality of the case, and they've put off a decision on whether the UK has complied until September of this year, well after the election. So we should wait and see what the new government does. And I think the main reason why the impetus has gone out of this reform is that the court has been bending over backwards to be helpful to the British government and other governments like the French government as well on a case about challenge to the burqa ban in France. Last month the court considered the case of more than 1,000 prisoners who'd been unable to vote in the election between 2009 and 2011. Yes, they said, yes, there's been a breach of the convention, sure, because we follow the Hurst case, but we're not going to give any prisoners any compensation for this breach of their human rights, and perhaps more importantly at all, we're not going to give any of their lawyers any of their costs back, so that will teach them to bring cases here. Now, you know, that's an achievement. Some Conservative lawyers have tried to persuade me that's because Chris Grayling has been, you know, making a fuss about things, and it wouldn't have happened if he hadn't threatened to pull out of the convention. But we shall see. No doubt there will be some sort of commitment in the human rights to human rights reform in the Conservative manifesto. Either that or David Cameron has been persuaded by Linton Crosby that his plans really won't stand up to informed scrutiny. Either way, I really don't think we shall be pulling out of the Human Rights Convention any time soon, and given the message that that would send to the other countries in Europe, and I don't think you'll be very surprised at my conclusion, given what I've been saying so far, but I don't think that it's going to be a bad thing. In fact, I really am very relieved that withdrawing from the ECHR question mark, no, I don't think we will. Thank you.
Thank you very much, Joshua. Joshua's also agreed to do about 10 minutes of question and answer, and afterwards I'm going to encourage everybody to go outside, and we've got a small reception with wine, etc. So there may be an incentive to keep a Q&A rather short. So if you'd like to ask a question, we'll probably take 2 or 3 at a time, and we'll probably do 2 or 3 rounds, depending on how short you are able to keep your questions. So, who would like to ask a question? So, gentleman there, and then gentleman at the front. So the gentleman there.
What's to be done about today's case, where the government has quite failed in respect of the prisoner, the miscreant who crashed his car, found to be carrying a lot of drugs, and has applied for compensation. And the judge himself said people would find this very, very strange indeed, but here we are, you've just got to pay a 6-figure sum for this.
I wanted to bring it to the street level and put it in the context of access to justice broadly, and the rise of the litigant person.
legal background.
Right, I'll start with the last one. He is the, people are not quite sure when the last time we had a Lord Chancellor who wasn't a lawyer was, but the general view, and certainly this is what it says on Wikipedia, is that he is the first non-lawyer to hold that post for 440 years. Now, I'm sure you knew the answer to that. It's very interesting. He actually says, he said in an interview with a website called Conservative Home a couple of months ago, that he actually thought that was an advantage, being a non-lawyer, because he wasn't going to be persuaded to support whichever branch of the profession he would have come from, solicitors or barristers. The interviewer was a man called Andrew Jimson was so shocked by this claim that it's an advantage to be a non-lawyer that he didn't ask Chris Grayling what he thought of the Lord Chancellors going back 440 years had suffered by being lawyers. The point, of course, is that until quite recently, the Lord Chancellor sat as a judge. The last Lord Chancellor to do so was Lord Irvine of Legg, who was a very serious lawyer. Before that, Lord Mackay of Clashfern, who was a judge before he was Lord Chancellor, and Lord Hailsham, who was a pretty serious lawyer. In other words, it's been possible for somebody to be Lord Chancellor as well as being to be Lord Chancellor, be a judge as well as a politician. It all got too difficult. Lord Chancellor is responsible for legal aid, he's now responsible for prisons. It's become a government department like every other, and the reforms announced by Tony Blair in 2003 and enacted in the Constitutional Reform Act of 2005 mean it's not necessary for a Lord Chancellor to be a lawyer. It's a pity. We've lost something. You don't have to be a lawyer, but you do have to understand lawyers and not be frightened of lawyers. And I think deep down, he's like these people who think, oh, a clever lawyer is always going to find some hidden precedent or some obscure act of Parliament and wrong foot me. And I think he feels rather threatened by that. And that's a pity. Okay, going back in reverse order, and this is connected. The previous question was about the rise of litigants in person. These are people who act in court for themselves in civil claims because they can't afford a lawyer and they no longer qualify for legal aid. And this relates to an Act of Parliament known as LASPO, Legal Aid and Sentencing of Offenders, I can't remember what it stands for, 2012, which basically took away legal aid from civil cases. It did allow for exceptional funding. The Lord Chancellor, Chris Grayling, has been found to, the guidance he issued has been found to be unlawful in at least a couple of occasions, and exceptional funding has been very, very narrowly applied. It was thought that there would be thousands of cases which qualify for exceptional funding. There have been a couple of hundred in a comparable period. In other words, the safety net hasn't worked, and there's been a rise in litigants in person, and the consequence of that is that some of the savings in legal aid have been dissipated because the courts are having to spend longer to deal with litigants in person. Our system of justice in civil claims depends on lawyers knowing the law. The judge may not know very much of the law. The lawyers are there to explain it. They tell the judge what's going on. If you don't have lawyers, at least on one side, to tell the judge what the law is, then you get bad decisions which have to be overturned on appeal, or you get the judges going off and having to do their own research, which, is rather a waste of judicial time. The system begins to break down if you don't ensure that litigants who have a case and need to go to court are properly funded. The question I was asked to begin with is this case about a car crash. I think the point was that somebody was uninsured, and I think the claim was against maybe the Motor Insurers Bureau, which supports uninsured motorists. I'm not quite sure of the details, but the argument was that because the motorist who was injured in this car crash was a criminal because he was carrying cannabis, he was therefore not entitled to the compensation that would pay for the medical treatment that he needed and needs as a result of being very badly injured in this car crash. I think that was the story. And the judge, as you rightly said, that's the law, and there's nothing we can do about it. He's a criminal, but he's still entitled to compensation for the car crash. Now, it's a question of policy. Do you say that because somebody is a criminal and they're carrying cannabis, which is a criminal offence, then they are to be deprived of the rights that they would otherwise have if they're involved in a car crash? Or do you say, well, it's nothing to do with it, you know, we all break some laws some of the time, and should this particular criminal behaviour disqualify us from being able to claim the compensation to which we are otherwise entitled? And that's a very clear question of policy, and one that you can have views on. And the answer to that is, if we, the public, think that the law should be changed, then we get our MPs to get the government to change the law through Parliament, and we say that these people don't get compensation. The best example of something comparable is compensation for miscarriages of justice. There's a bit of a myth around that if you are the victim of miscarriage of justice, you get compensation. That is very much a myth. It's a very narrow field now, and you can be released after serving 5, 10, 15, 20 years in prison. You're cleared on appeal when new evidence comes to light, and you won't get compensation unless you can effectively prove you couldn't possibly have committed the offence. And what Parliament is saying to people is, well, we haven't got the evidence to prove you did it, but just because we can't prove you did it, it doesn't mean you didn't do it. And so there is this stigma over people, and you get people released from prison, having been cleared, who are not guilty in the eyes of the law and get no compensation for 5, 10, 15 years in prison. Now, is that right? Well, if you think they did it, you will say, of course they shouldn't get compensation, they're jolly lucky to be let out. If you think they didn't do it, and they're let out, you think it's an appalling thing that the state has taken away their life. They may be, all sorts of things happen if you spend a very long time in prison, you're unable to work, life has changed. Surely you should get compensation. So these are matters of policy on which people have views.
Thank you, Joshua. I think one final round of questions. So, any questions?
As a student, I was wondering what caused you to transition from being a practicing lawyer to a journalist, and what being a lawyer has brought to your journalism career.
Excellent question, thank you. Any more questions? Oh, I think we'll use this as the final one.
Just keen to hear your thoughts on the Ireland versus UK case.
Just remind me a bit more about that.
The 5 techniques.
Five techniques, yeah. Torture. Yeah, okay. I haven't looked at the Ireland against the UK case in detail. If you gave me 5 minutes and said I was going to do a broadcast on it in half, and then, well, as I say, if you gave me a bit of time and said I was going to do a broadcast on it in 5 minutes, I would look it up and I would tell you. But I don't know enough about it to give you my view. I haven't read on it, but it's a rare example, isn't it, of, and this is a case before the European Court of Human Rights, and it's a case between governments, which is pretty unusual. That was, to some extent, how the Human Rights Court started before you had the right of individual petition. It was governments against governments, but that's very rare, it's much more unusual that individuals bring cases. If the Human Rights Court says that these 5 techniques of, hooding and silence and noise and so on, are a breach of the Convention, and I can see that they may well say that, then the British government will just have to accept that. I mean, this is presumably Article 3, no one shall be subjected to torture or inhuman or degrading treatment or punishment. And on the face of it, I think the Irish government, on behalf of the victims of this, have got a jolly good case. And the consequence will be that the UK will simply have to put that decision into effect and will have to say, we won't do this. The UK government has said, we don't do this anymore, I think, and that's what they will have to do. Otherwise, they will be in trouble on enforcement. And then the last question I'm going to answer then is, what am I doing here? Why am I here? Why didn't I go off and make some money as a lawyer? Well, I'll tell you what happened. I did a law degree at another university, and I then decided to train to be a solicitor at a little suburban practice on the outskirts of London. And I was sort of meandering along in a happy sort of way, and we had some friends, and one of them worked for the BBC, as a secretary. And she worked in the appointments department, and the appointments department was at that time advertising for trainee journalists to join a journalism training scheme at the BBC. And she said to my wife, who was then training on a newspaper, why don't you join the BBC training scheme? It looks very good. And my wife said she was very happy with newspapers. Somebody, I think it was my wife, it could have been this friend, but I think it was my wife, said, well, why don't you apply? And I thought, well, I'm not a journalist. I've never had any particular interest in journalism. I'm meandering along as a trainee solicitor. Why would I want to apply to change my career? And not taking it very seriously, I sent off an application form. It all sounded rather glamorous. It said, candidates will be required to take a voice test. I've failed the voice test at the moment. But anyway, it all sounded right. Anyway, eventually interviews and so on and so forth. And a letter arrived saying you've got a place on this training scheme. And I then had to make a decision, as one does in life, not very often actually. This was really the only decision I had to make, any great significance. I suppose the second one was leaving the BBC, but the first one was, should I join the BBC? And the way I rationalised it was, first of all, and this is perhaps addressed to the students here, first of all, when opportunities come your way, take them, because you will always regret not taking opportunities when they come. It may go wrong, it may be bad, but take the opportunities in order to see what will happen to you if you take the opportunity. Otherwise, you always think, what might have been? So that was how I rationalised it. I knew what would happen to me if I stayed being a suburban solicitor pretty well. I had no idea what would happen to me if I joined the BBC as a trainee journalist. So I took the post. After a while, after I'd been there for about 10 years, they decided they wanted somebody to specialise in legal affairs. I was in the right place at the right time, basic rule of journalism, good luck, good fortune, stayed doing legal affairs for them for 15 years, offered a job on the Daily Telegraph, followed my own policy, which was leave. That was probably a mistake, but nevertheless, that was my guiding principle. Left the Telegraph, freelance. And here I am tonight.